With regards to the grand jury transcripts, I recognize that councils have had an opportunity to talk about that. Is there anything you wish to place on the record with regards to those motions?
I do, Judge. Thank you. Your Honor, I just want to make a record here, in addition to what I filed with the court, in an acknowledgement that the grand jury proceedings with regard to the homicide of Aliza Sherman are very unique. And there have been multiple grand jury proceedings over the years dealing with not only the bomb threat investigation, which did generate a number of indictments and one information, but simultaneous to some of that was evidence regarding Aliza Sherman's homicide. And that was, at this point, 10 years ago, and 11 years ago, and 12 years ago. And now we have an indictment so many years later. The case law is not clear as to what constitutes a particularized need of a defendant. The case law talks about a defendant's right to have grand jury transcripts in the unique circumstance where the defendant does have a particularized need. But it doesn't describe what that is and how a court is supposed to find that out and figure that out. And what I don't want is for this to be the case where, on appeal, if the grand jury's transcripts are not given, a court of appeals says they should have been. And so we don't know exactly how to determine particularized need, but I think if it does exist, it exists here. And so what I would recommend is that the court order the grand jury transcripts to be sent to you, the same ones that have been sent to me, and the court does its own in-camera inspection of them to determine if the party's recommendations that there is a particularized need is correct. I think the court will find that and then order their release. Thank you.
Thank you. Captain.
I guess what I'm hearing the state say is that there's a joint stipulation that there may be a particularized need in this case. And if there is that joint stipulation, obviously we ask the court to consider that.
Thank you so much. And I have had an opportunity to review those motions. Since there does appear to be a stipulation as to the particularized need with regards to the grand jury transcripts, what this court's inclined to do, having reviewed the case law and the motions and the arguments by parties, this court at this time will order the disclosure of the transcripts for in-camera inspection by the court. I believe those sets of transcripts are specifically the ones listed in the motion, which are December 5th of 2013 for case number CR 13580-258. The second being from March 4th of 2015 in case number CR 15593-822. The third being from January 28th, 2016 in case number CR 16603-059, and the fourth being from May 2nd, 2025 in case number CR 25701-663. So I will order those to be sent to the court only at this time. I'll hold the motions in abeyance until I have those reviewed, and then the court will make a determination as to whether a protective order will be issued for counsel-only designation on the grand jury transcripts, even though the court has acknowledged that there is a stipulation as to the particularized need on this.
If I could, I'm sorry, with regard to that, those are the dates where charges may have resulted.
Okay.
There are various other dates where charges did not result. So,
are there additional dates that I should be including in the order, counsel?
I would actually encourage the court not to put dates
Okay.
on that and just order transcripts related to the indictments and certain case numbers. I can get that to the court, as well as the investigation into the bomb threats and Aliza Sherman's homicide.
Okay. If there are specifications, since you are aware of that,
Yes.
I would just ask that you exchange that with defense counsel so that I can include those specifics in my order to have those ordered to myself, just
Yes.
so I can have those. Okay, great.
Thank you.
And then I'm going to hold the motions for grand jury transcripts in abeyance until the court has those reviewed, as I previously mentioned. We've already set, we have those motion dates for June 29th and June 30th. And then we've already adjusted the reply schedule at the request of the parties. And then counsels for a next Zoom attorney conference. Does June 2nd of 2026 at 11:30 work for everyone?
Yes, Judge.
It does, Your Honor.
Okay.